The civil liability for interrogation violations? Yes. This Chavez versus Martinez police officer shot Martinez during an investigation? Yeah. hmm he also admitted that he used heroin regularly. At no point during the interview was Martinez given Miranda warnings. Oh, Martinez was never charged with a crime. His statements were never used against him in any criminal prosecutions. He sued Chavez under Title 42 U.S. Code 1983, alleging violations of the Fifth Amendment right against self-incrimination and 14th Amendment due process rights. Ouch. Now, I wasn't in Sequim, Washington, but I was interviewed for a crime that I didn't commit. The probable cause arrest, but the Violence Against Women's Act is not enforceable without the due process rights of the respondent being enforced. I told the Sequim Police Department, I told you, on November 20th of 2015, that when you did not give me actual notice and opportunity to be heard, you could not have a probable cause arrest. You would have been required to get a warrant for my arrest. Now, when you decided in your civil conspiracy that you were going to issue a traffic citation where I wasn't in Sequim, Washington, the actual interview that Officer Larson did violates numerous laws about having a valid protection order. Without the signature of the petitioner and without due process, there was no way you could have had a court hearing. Now, instead of dismissing the case against me, Judge Porter, you decided to put me in jail for 27 days so that you could obligate me to the interrogation known as a mental health evaluation, pooch, so that you could label me as being unspecified bipolar and unspecified schizophrenic with a small amount of psychosis. Now, every time you require a mental health evaluation without a valid protection order, it happened to violate the requirements of the VAWA and every Now, these interrogations, known as mental health evaluations, where the state decides they're going to label a person as delusional, when I told Phyllis what the actual law says, and the actual law that is printed on the Washington State Court website says that you have to give the respondent at least 5 judicial days prior to a hearing, and there must be proof of service before you can issue that order. Now, you want me to talk to an expert, or am I going right to the mental facility? Because a mental health evaluation that's being used as an interrogation, pooch, to ask an individual any question they want because they did not have any jurisdiction of law. There's forgeries. There's duress of the signature of the ex officio court officer. There's the fraudulent use of court seals. Then there's a little local conspiracy that everybody's going to laugh their ass off and they're going to make me have involuntary medication. Well, the truth of the matter is a mental health evaluation without a valid protection order is a fucking interrogation with the threat of incarceration in a mental institution so that you can prescribe psychotropic medications. Now, I'm thinking that violates certain Supreme Court precedents. You cannot obligate a person to a mental health evaluation unless the protection order is valid. Do you understand, prosecuting attorney? Now, you said, well, as long as they issued it and he has knowledge of it, the problem is it violates the laws. Now, I'm going to want my sons, and you deciding yesterday to have another court hearing, would be another interrogation, without the authority of law. So your abuse of the mental health evaluation and treatment, if recommended, without the enforcement of the due process laws, because you think you don't have to give any due process to the disabled, violates the rights of every citizen of the United States. And your whole thought that you can just obligate somebody to be interrogated by a mental health professional,